My dear student, we are going to discuss on the topic torture, rape and killing of women and children. Introduction. Nature creates man and woman equally. Physical, moral and spiritual union of man and woman is the condition precedent for the progress and the continuity of human civilization. The institution of marriage and family procure child who are the future of mankind. Most of the religions of the world prohibit torture of women and children and advise men to treat women and children humanly. It is said in the Hindu scripture that having divided his body into two parts, he, the Lord Brahman, became man by means of the one half, and female by means of the other. The UN Charter has not only reaffirmed the basic principles of equality of man and women, but also taken up various measures to prohibit torture, rape, and killing of women and children. In addition to many global declarations and conventions, special conventions were also adopted for the promotion and protection of basic rights of women and children. Such conventions expressly prohibit torture, rape, and killing of women and children, and the atrocities and the discrimination against them. India is the largest country in the world in terms of its population. Women and child population of the country constitutes more than a half of its population. The Constitution, apart from guaranteeing fundamental rights, incorporates special provisions for women and children in the Article 15, which enable the Parliament to enact special laws for them. The Criminal Law Amendment Act 2013 brought a drastic change in the criminal jurisprudence. The Northeast India is affected by insurgency, ethnic conflict, and also suffers prolonged deteriorating law and order for the last many years. There are reported as well as unreported cases of rape, torture, and killing of women and children in the region. Torture and inhuman acts. Torture destroys the personality of the victim completely and denies the inherent dignity of human being. Torture always starts with arrest or domination of the victim. It is absolutely prohibited by law and is a crime under both municipal and international law. Torture cannot be justified under any circumstances and forms part of customary rules of international law. The UN Special Rapporteur on Torture asserted that prohibition of torture could be the rules of jus cogens. Such rules are non-derogable, which applies to all states of the world. Women and children are subject to torture at public as well as public sphere. Rape, kidnapping, abduction, abandonment, procuration of minor girls for prostitution, buying or selling of girls for prostitution are also different forms of torture. Children of India are subject to such kind of torture. According to National Crime Records Bureau, 47.9% of the crimes committed against children in the year 2012 are the crime of kidnapping and abduction. The National Crime Records Bureau shows that torture cases in the country increased by 7.5% in the year 2012 in comparison with cases reported in the year 2011. There were 106,727 incidents of cruelty by husband or his relatives in 2012 as against 99,135 cases in 2011. The highest crime rate of 47.8% was reported from Tripura. The term torture has not been defined in the Constitution of India or in any other penal laws of the country. Article 21 of the Constitution only provides that no one shall be deprived of his life or personal liberty except according to the procedure established by law. The term life and personal liberty has been built to include the right to live with human dignity and therefore includes within its ambit a guaranteed against torture and assault by the state or its functionaries. Any person subjected to torture or to cruel, inhuman, degrading treatment or punishment can move the higher courts for the various judicial remedies under Article 32 and 226 of Constitution. The Indian Penal Code does not recognize torture as a separate type of crime. However, it prohibits those acts which may constitute torture and inhuman, degrading treatment to women and children. The Indian Penal Code criminalizes rape, kidnapping and abduction, and abandonment, procuration of minor girls for prostitution, buying or selling of girls for prostitution, which constitutes torture. Women are subject to cruelty by husband and his relatives. Section 498A of the Indian Penal Code provides that whoever being the husband or the relative of the husband of a woman subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years, and shall also be liable to fine. Over and above, the Parliament has enacted the Protection of Women from Domestic Violence Act 2005 to protect women from domestic violence. The Universal Declaration of Human Rights, UDSR, adopted and proclaimed by the United Nations General Assembly, prohibits torture. The provisions of the UDSR are obligatory on the part of the state by virtue of being acquired the force of customary rules of international law. The International Covenant on Civil and Political Rights, 1966, and the Child Rights Convention, 1989, expressly prohibit torture and inhuman, degrading treatment. Article 1, Clause 1 of the Convention Against Torture and Other Cruel, Inhuman, Degrading Treatment or Punishment, 1984, defines the term torture as an act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purpose as obtaining from him or a third person information or a confession, punishing him for an act he or a third person has committed or is suspected of having committed, or intimidating or coercing him or a third person, or for any other reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of or with the consent or acquisitions of a public official or other person acting in an official capacity. Apart from recognizing the right to fair and adequate compensation to the victim or his dependents in case of that of the victim of torture for rehabilitation, the Convention obligates the state parties to impart education and disseminate information fully regarding the prohibition against torture in the training of law enforcement personnel, civil or military, medical personnel, public officials, and the other persons, whoever may be subjected to any form of arrest or detention or imprisonment. India has signed and ratified the International Covenant on Civil and Political Rights 1966, and the Child Rights Convention 1989. Even though India has signed the Convention Against Torture and Other Cruel, Inhuman, Degrading Treatment or Punishment 1984, she did not ratify the said convention. Extreme form of sexual offense. Rape is the most heinous crime committed against women, which shocked the conscience of the victim. It is not only a crime against the person of the woman, but also a crime against the entire society. The International Criminal Tribunal for former Yugoslavia, established by the United Nations Security Council, observed that rape constitutes war crimes and a crime against humanity. The Indian Penal Code expressly prohibits rape. The Criminal Law Amendment Act 2013 has brought a drastic change in the provisions of law relating to sexual offences. Section 375 of the Indian Penal Code defines the term rape. Similarly, Section 3 of the Protection of Children from Sexual Offences Act 2012 defines it. However, the said Act uses the term penetrative sexual assault instead of rape. The reason for it might be to protect the victim of rape from stigma and discrimination in her future life. The maximum punishment for rape shall be rigorous imprisonment for a term which shall not be less than 7 years, which may be extended to imprisonment for life and also liable to fine. The Criminal Law Amendment Act 2013 enhanced the quantum of punishment for gang rape. The convict shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to life, which shall mean imprisonment for the remainder of that person's natural life and with fine. The modesty and the dignity of women is being threatened by the orders of the kangaroo courts constituted without any legal sanction in India in recent past. A tribal woman in Birbhum district of the West Bengal was gang raped by 13 persons under the order of a Khap Panchayat in the early part of this year 2014. She was asked to pay a sum of rupees 25,000 as fined by the Khap Panchayat, for she allegedly fell in love with a boy from another community. As she was unable to pay the fine, she was gang raped by 13 persons by the order of the Khap Panchayat. The National Commission for Women took suo motu case and conducted inquiry into the incident. The Supreme Court also took suo motu cognizance of the gang rape of the young tribal woman and directed the district judge to file a report to the Supreme Court. The adoption of Rome Statute 1998 by the UN General Assembly is a landmark in the history of concretization of international criminal jurisprudence. Article 7, Clause 1, Subclause 7 of the Rome Statute stipulates that rape constitutes crime against humanity and war crimes. The Child Rights Convention urges the state parties to undertake measures to protect child from all forms of sexual exploitation and sexual abuse, and to take up appropriate national, bilateral and multilateral measures to prevent it. Killing of women and children. Right to life is the most fundamental and basic human rights of individual, without which other human rights would be meaningless. Life of women has been threatened even before birth. Female infanticide still remained a critical concern of many countries of the world. In recent decades, sex ratio imbalances in favor of boy children have grown in a number of Asian countries. India has also possessed the hateful legacy of killing of female child. It is also estimated that more than 1 million selective female fetal abortion occur annually in India. There is no official statistics that are available on female infanticide. India has the evil tradition of honor killing. The practice has visibly resurfaced in different parts of the country, particularly in the northern state of India in the recent past. An honor killing is the murder of a member of a family or a social group by the other members due to the belief that victim has brought dishonor upon the family or community. Honor killings are directed mostly against women and girls. Many girls of these northeastern states have been the victim of such evil practice, reinforced by the male-dominated Khap Panchayat. The Supreme Court observed and warned that all persons who are planning to perpetrate honor killing should know that gallows await them. Extrajudicial killing is the imposition of capital punishment without judicial guarantee. The people of Northeast India, especially women and children, are under the threat of such killing. Because of the prolonged imposition of the Armed Forces Special Power Act 1958, which empowers even a non-commissioned officer of the army to kill any person on the ground of mere suspicion. The arrest, detention, torture, rape and killing of Thangjam Monorama by the security forces in 2004 and the killing of Thoksom Ravina, a pregnant woman, in the heart of Imphal city by the police in 2009, when the police were allegedly chasing and firing on a suspect insurgent, are glaring examples of extrajudicial killing of women and children in Manipur for the last 5 decades. The UN Special Rapporteur on Violence Against Women, Its Causes and Consequences, Rashida Manju, visited Manipur in 2013 and expressed deep concern over the disappearance of young women, sexual abuse, exploitation and trafficking. The Constitution of India guarantees right to life and the personal liberty of individuals. Article 21 of the Constitution provides that no one shall be deprived of his life and liberty except according to the procedure established by law. In Maneka Gandhi versus Union of India, the Supreme Court held that no law can deprive a person of his life or personal liberty unless it prescribes a procedure which is reasonable, fair and just, and that if it is not, the court will strike down the law as invalid. After this judgment of the apex court, the Article 21 assumed a new dimension. Legislation consists in pronouncement of legal rules by competent authority of the state. The Indian Penal Code 1860 prohibits and criminalizes murder. Section 302 of the Indian Penal Code provides that whoever commits murder shall be punished with death or imprisonment for life and shall also be liable to fine. Section 312 to 318 of the IPC deals with offense relating to causing of miscarriage, of injury to unborn children, of the exposure of infants, and of the concealment of birth or with birth. On top of it, the government has also enacted many legislations for protection of the life of unborn child, including the preconception and the prenatal diagnostic technique, prohibition of Sex Selection Act 1994, and the Medical Termination of Pregnancy Act 1971. The International Bill of Rights guarantees right to life to every individual. The Universal Declaration of Human Rights proclaims that everyone has the right to life, liberty, and the security of persons. The International Covenant on Civil and Political Rights 1966 also stipulates that every human being has the inherent right to life. This right is recognized as non-derogable rights by the family of nations. It cannot be suspended even during emergency. The second optional protocol to the International Covenant on Civil and Political Rights was also adopted by the UN General Assembly in 1989 with a view to abolish that penalty. This shows the importance of right to life of every individual, including the life of a hardened criminal. The Convention on the Rights of Child 1989 expresses in its preamble the need for special safeguards and the care, including appropriate legal protection of child before as well as after birth. Article 6 of the Child Rights Convention obligates the state parties to recognize the inherent right to life of every child. Conclusion. It is the responsibility of the male member of the society to protect the weaker and the most vulnerable section of the society. Legislature as well as law enforcement machinery of the state are also equally responsible to enact laws relating to women and children and to enforce them effectively for better protection of women and children in the country. The government has enacted many protective laws for women and children. However, crime against women and children, especially crime of torture, rape, and killing, is increasing in India as per National Crime Records Bureau report. The government of India ought to take up suitable measures for a speedy passing of the Prevention of Torture Bill 2010 at the earliest, so as to prohibit torture in the country in the better way. Rape and killing have been prohibited in all human society since the inception of human civilization. However, such human acts continue to threaten women and children in almost all countries of the world. Torture, rape, and the subsequent death of Nirbhaya in 2012 in the national capital Delhi brought a dramatic change in the criminal law of India pertaining to the sexual offences by passing the Criminal Law Amendment Act 2013. The law enforcement machineries of the state have to implement the amended criminal law with dedication so as to prevent commission of heinous crime like rape and the killing of women and children in India.